for coming up with a wonderful topic and also amassing this wonderful group of panelists today and for the entire day. I think we started out with a very interesting new perspective, the misalignment theory. I want to thank Professor Stephanopoulos for that. So the timing, obviously, the McCutcheon case. On Wednesday, in Justice Breyer's dissent, he laments, taken together with Citizens United, today's decision eviscerates our nation's campaign finance laws, leaving a remnant incapable of dealing with the grave problems of democratic legitimacy that those laws were intended to resolve. Unlike our dean, I'm wearing blue today. But in any event, I think what that statement suggests is that all of this goes back to Citizens United. It's the two together. And the McCutcheon decision obviously is brand new. We don't know the impact. But what this first panel is going to focus on is Citizens United. It's now been 4 years. And so we can have a meaningful conversation on the impact of what that decision has had on the political landscape. We have a very eminently qualified panel of three. I am going to just very briefly introduce them because, first, we're running behind, but in addition, I would rather let them have the time. They'll each have about 20 minutes, 5 to 10 minutes for questions at the end of each of them. So I'll start out very briefly introducing them in the order in which they will speak, beginning with Professor Smith, who is at Capital University Law School. He is visiting this year at the West Virginia University College of Law. He's a federal elections expert. He has served as past chairman and commissioner of the FEC from 2000 to 2005 and has written extensively about federal election laws. He lectures frequently, presents, writes, and blogs on federal election issues, and he's testified before Congress numerous times on this issue. Our next speaker will be Richard Briffault, who is the Joseph Chamberlain Professor of Legislation at Columbia. He too teaches a course in election law. He has written extensively, lectured on this topic. He has served as the executive director of the Special Commission on Campaign Finance Reform for the ABA of the City of New York. So he has an interesting perspective on that. Fran Hill, our third speaker, is at the University of Miami Law School. Her expertise is actually our three topics for today: federal tax law, constitutional law, and federal election law. And her expertise is really in the area of exempt entities in campaign finance. And she co-authors a treatise on taxation of exempt organization. Like our other panelists, she too has testified before committees on Congress and the FEC on a range of exempt organization issues. She worked with Jones Day in both its Washington and London offices before she became a law professor at the University of Miami. So I welcome our panelists and I look forward to the discussion.
Okay, I guess this is live?
Yes.
Yes.
Yep. All right, I guess I'm supposed to be first, so thank you very much for coming out. I appreciate it. If you might want to use the restroom if you need to, I'll be about 2 hours to talk to you.
I'm keeping time
Oh.
on.
Okay. All right, well then in that case, I'll have to try for an abbreviated version. When discussing Citizens United, I think it's always useful to begin by remembering the position taken by the United States government in the case. The position of the United States government was that the government has the right, under the Constitution, to prohibit the publication and distribution of a book, movie, or pamphlet that includes even one sentence advocating the election or defeat of a candidate, merely because it is published, financed, or distributed by a corporation, such as, say, Barnes & Noble selling a book, or McGraw-Hill publishing a book, or Disney making a movie. That was the position of the United States government. And contrary to what some have said, that was not a position disavowed during the second round of oral arguments in that case. Indeed, during the second round of oral arguments in that case, then Solicitor General, now Justice Kagan, very specifically made clear that that was still the government's position, but she promised that the government would use that power responsibly. Now, when we remember that that's what the case was, that's what the issue was. Could you prohibit a documentary movie about a major United States politician during an election year? It is remarkable to me that 4 justices on the court said, yeah, you can do that. The government can do that. That was the position of Breyer, Sotomayor, Ginsburg, and at the time Stevens, now replaced by Kagan, taking that same position. These are the radicals on the court. And this is, as much as anything, the strong rationale for tremendous skepticism about the campaign finance project and why we should be, I think, generally cheered by yesterday's decision or Tuesday's decision, and in particular Wednesday, whenever it came out, and in particular the skepticism that the court showed about government efforts to regulate in this area. Now, passing campaign finance law has always been hard. It has certain built-in advantages if you want to pass a law regulating money in politics. People don't like politicians, they don't like campaigns, and they don't like money in politics, right? And there are good reasons, by the way, for not liking all 3 of those, but especially for being concerned about money in politics. I think there are valid reasons why people have those concerns. But still, it's not easy to pass these kinds of laws. Substantively, for one thing, a certain amount of political distrust is built into the political system and ought to be built into the political system. So when the argument goes, well, we have to do something about the great distrust in government, we need to be very careful about that. Our government was founded on distrust in government. And you should always ask yourself, what would you think if people just said, if you're a Republican, just say, well, Eric Holder says we ought to do this, so I guess it's right. If you're a Democrat, I guess you have to think back a ways now, but think, would you have just said, well, that's what John Ashcroft says we need to do for national security, so I guess that's it. No, we believe that there should be a certain level and a healthy level of distrust in government. Secondly, I would say that Professor Stephanopoulos' position to the contrary, or maybe not to the contrary, but I guess I would say in the context that most people think about it, that money corrupts politicians, there is simply very little evidence that that is the case. And indeed, it is fair to say that the overwhelming majority of studies have not found that money operates in that fashion. Now, it may be that we will begin to find, as more of this new political science research comes on, that money operates in another fashion we're concerned about. But the traditional argument has been that money is corrupting these politicians in a direct fashion, and there's very little evidence for that. And third, we know that the vast majority of spenders and contributors are not corrupt. That's always been admitted. Sometimes people forget that when we get caught up in rhetoric and so on. But most congressmen are not corrupt, and most donors aren't corrupt. Most donors never even ask to have a meeting with the congressman or senator who may give them money. And this even includes big donors. Right? As Justice Roberts pointed out in his opinion earlier this week, the mere idea of limiting contributions generally is in fact a prophylaxis rather than a direct response to corruption. It's a prophylaxis against the relatively few contributions that are found or have been found to be intended to serve as bribes of the sort. Now, given this, we also have to deal with the fact that campaign finance regulation has always been a real priority for voters. Poll after poll has always shown this to be down near the very bottom of what voters are concerned about. And there's some rationality in this. Voters are more concerned about jobs and things like that. Not to say they're not concerned about it, but it's not near the top of their list. It's interesting as I've gone back to look historically at the issue. The issue's been out there for a long time. There's always been a level of public concern, and it waxes and wanes. But for the most part, people have long accepted a generally deregulated system of political finance in the United States. If we go back and we look at Austin versus Michigan Chamber of Commerce, the decision overruled by Citizens United, 1990 decision, Austin is, we find that at the level of those intensely engaged, the debate was remarkably similar to today, but just with the shoe on the other foot. Justice Scalia read his dissent from the bench. That's always supposed to mean that it's like really, really important. Right? They've been highlighting that about Justice Breyer doing that this week. Justice Scalia in his dissent noted that the court was overturning 70 years of precedent. Now the argument is the court's overturning 100 years of precedent. So I guess there's a big overlap of the precedent there when everybody's in agreement or something like that. But there was very little public passion at the time. The databases, of course, are not as good for that time period. You can't find as much in the databases. But if you go back and you look at the Lexis and Westlaw All News databases, you'll find that there is not a single article in the papers that pops up about Austin versus Michigan Chamber of Commerce between December of 1987, when it was decided by the Court of Appeals, and there were one or two short little articles mentioning it, and October of 1989, when it appeared on the court's docket for the 1989 term. And then there were a few articles, but if this case was on the docket, it would be an important case. There are then no articles at all from October of 1989 until March of 1990, when the case is decided and issued. No articles the week before, this would be a big case. Nothing like that, right? When it was released, it was important news. It made page 2 in the Washington Post. It was not front page news. There were not a raft of editorials. It was not something where people say, thank God we dodged a bullet there, right? It was just not considered that passionate an issue for the general public. Now, why do I mention this? Well, because if you really believe that this kind of regulation is beneficial, you've got to generate public support for that. And how might one do that? Well, one might do that by essentially spending millions of dollars, hundreds of millions of dollars, to convince the American public that their political system has simply gone to hell in a handbasket. Okay? And that is largely what the story of campaign finance reform is. Coupled with the second thing that you have to do, which is align yourself with whatever opportunistic politician you can find who wants to restrict the speech of his political adversaries. Those, I think, who have studied in detail the passage of campaign finance reform bills over the years, starting with the Tillman Act in 1907 on through, have generally found that you pass these laws by getting a combination of a relative handful of idealists and a large number of cynical, realistic politicians who think that this law will benefit them by restricting the speech of their political opponents. And you see this on both sides of the aisle, whether it's Republicans in 2004 trying to pass regulations and laws restricting Democratic-leaning 527 groups, as they were called, or whether you see Democrats today attempting to pass the Disclose Bill in Congress to cut off what they think is Republican-oriented interest, or whether you see Ben Tillman in 1907 trying to cut off the interest of corporations because corporations were opposed to his segregationist agenda in the Deep South. And you see that pretty much up through history. The end result, then, is that the very effort to pass this reform leads to a tremendous amount of loss of confidence by the public in the integrity of their politicians. We go from a healthy skepticism of government action to an unhealthy skepticism that holds that they're all corrupt, which they clearly are not, but you hear that all the time, and many of you would perhaps believe it or have said it. Right? And a belief that every action can be explained by money, which is simply not true, I think, to anybody who realistically has been around in Washington. This is, as I call it, the we need to destroy the village in order to save it approach. This comes from a famous and perhaps apocryphal story that the journalist Peter Arnett published back during the Vietnam War. He allegedly talked to some colonels who had obliterated a Vietnamese village, arguing that there were Viet Cong there, and he said one of the colonels actually made the statement, we had to save the village, we had to destroy it. And that has largely been the approach of campaign finance. If we want to look at public trust in government, and we're told that we have to build this public trust, and I think this is perhaps an element of the sense of alignment, right? We find that when the Federal Election Campaign Act was passed, public trust in government as registered by polls was at about 70%, okay? By 1954, or 1974, when we had the major amendments to the Act that gave us more or less our current system, public trust had eroded to about 54%. Okay? It continued to erode and dropped significantly into the early 1990s when the soft money explosion begins. People discovered the soft money loophole. Remember when that was the great fear. During the period of the soft money loophole being exploited, public confidence in government actually reversed and began going up. People began feeling more confident in government. And this continued up through 2002 when the McCain-Feingold bill was passed, which almost on the day that the McCain-Feingold bill was passed, the trend reversed and public confidence in government institutions and their integrity again began to plummet, plummeting to about 19% at the time of Citizens United, and then over the past 4 years, recovering just slightly into the low 20s, despite the government shutdown, which was the last time the poll was taken. Now, I don't purport to say that campaign finance drove these numbers down or that soft money drove them up. There are many, many factors there, and they're primarily related to the economy and other issues of that sort. Of course, Watergate drove down numbers during the 1970s. The other period in which confidence went up was during the early Reagan years when the economy was booming, and of course that was the case in the 90s as well. But clearly there's little reason to believe that campaign finance reform boosts public confidence in government, and therefore has much to do with an alignment theory or much of anything else, if we view at least that as part of that sense of an alignment theory, that view that people feel that their government is now responsive to them in some particular way. Now, these attacks certainly hurt, but it wasn't just these attacks. It was also the fact, I want to suggest, that campaign finance regulation has failed rather miserably in its goals. I have written on this extensively, others have as well, Jim Bott back there has as well. Here, I don't have time to go into that. We can simply note a few data points. I mean, prior to the passage of the Federal Election Campaign Act in 1974, which was the first time we put any limits on individual giving. Before that, when we elected Eisenhower and Truman and Kennedy, there were no limits on individual giving at all, let alone an aggregate limit. At that time, incumbents outspent challengers by about 3-2. Very quickly after the passage of that act, that ratio went to about 4-1, and it has hovered there since. There are reasons why that is true. I don't have time to go into those today. Suffice to say, that is not mere coincidence. There are reasons related to how money works in politics and how people solicit money in politics that made it predictable that that would be the result, and helped to explain that result in retrospect. Incumbent re-election rates, always high, they should be high, I think, rose from the low 80s, mid-80s, up to as high as 98 and even 99% after we passed these restrictions on giving. We found that candidates, of course, naturally spent much more time fundraising because it was much harder to raise funds. It was many more restrictions, much lower amounts that could be given, and that then was viewed as a reason for needing still more regulation. It should also be noted, and I do this just as sort of an initial thought, actually. I made a couple references to Professor Stephanopoulos' presentation, which I thought was very interesting and very good, and I'm very interested in some of the recent political science research he's put out. But I do note that the law itself was an anti-alignment law, at least that's my first take on it, in the sense that the law diminished the role of PACs. In fact, PACs were considered the big evil. They were the great danger that we had to prevent. It also diminished the role of political parties, which I think, much like PACs, serve an ameliorating function between donors and candidates, that parties have an interest in playing more to the center than any individual candidate does. The law was very much designed toward individual candidates and toward the idea that parties were a bad thing in the law. In addition to these sorts of trends, and there were others, of course, scandal did not go away. We had the ab-scam scandal, popularized recently in the movie American Hustle. We had the Keating Five, and so on. I think it's very hard for anybody to argue that we've really had significant benefits from this 40-year experiment. And by 2007, when the Roberts Court began its steady dismantling of these laws, it's worth noting that we had more regulation of political speech and campaign finance than at any time in the nation's history. And even today, we have more regulation, even after this week's decision, than we've had for most of American history, particularly in particular sorts of ways, such as limits on individual giving. Now, what do you do here? What has been the results of Citizens United these 4 years? Well, it's very tentative. It's still a bit early to draw some conclusions, but we can look at a few things. First, challengers have a much better shot now because money can enter quickly into a race when it turns out a candidate is vulnerable. I won't, again, in the interest of time, go into numerous examples I have in other forums, other fora talked about some of these problems, and I also have commented on the fascinating attribute in which incumbent congressmen, especially those who've just lost, call Citizens United a fascist decision and complain about the horrific fact that hundreds of thousands of dollars in independent expenditures were spent against them. One of my favorites is Dan Maffei, who got defeated, but now is back in Congress. Maffei complained about this vociferously, how totally unfair it was. Groups came in and spent about $500,000 in his district. And they almost certainly did cost him the election because he only lost by like 100 votes. Maffei has never once complained about the fact that even with that independent spending that went for his opponent, he outspent his opponent in that race by over 4 to 1, by a couple of $1 million, right? That's never bothered him in the least. Only that someone was spending money against him was a problem. We've also seen that the presidential races have been better, much longer. Remember, it used to always be, you lost the New Hampshire primary, it's pretty much done. 2012, we saw the elections carry on. This is because super PACs, in fact, helped to keep afloat the candidacies of a number of challengers. I think these challengers were seriously flawed, and in the end, they didn't win. But I don't think the supporters of Newt Gingrich or Rick Santorum thought this was a bad thing that their views were aired in public. I don't think it was a bad thing that their views were aired in public and ultimately rejected by Republican primary voters, and I think had they somehow won, would have been rejected in the general election. We note that all the horror stories about Citizens United have not come to pass. We don't have our system of washing foreign money, as the president suggested we might. There's complaints about disclosure, the amount of money which is, all spending is disclosed at some level. The amount of money which the donors are not itemized amounts to about 4% of political spending. You know, if you put it in terms of $350 million, it sounds like a lot. If you put it in terms of 4% of spending, it doesn't sound like very much at all. I think we can live with that pretty well, and much of it's well known. So I think that we are finding that Citizens United has generally had healthy effects. It certainly is hard to suggest that at this point it has had detrimental effects, other than by simply conclusively arguing that its effects are detrimental, that it's bad that people are spending a lot of money, without really arguing why it's bad that people are spending a lot of money. The result is, as people get used to Citizens United and accept it as part of the landscape and realize not only has it not been bad, it's probably had some salutary effects, is ramped up rhetoric. So yesterday's decision is relatively minor. One thing the government kept, or this week's decision, one thing the government kept arguing was, something about 600 people even hit the aggregate cap. And that's true, which suggests that the impact of the decision may not be that great. Right? Let's suppose that it results in 200 people each contributing $1 million in new money, totally new money, money they wouldn't have found any other way to spend otherwise in independent expenditures or anything else. That would be an additional $200 million to our system. That would be significant in one sense, but it would probably be about 2% of what one would expect to be spent in 2016 anyway, right? It's just not going to be that much. Most of that money will probably flow to candidates and parties, and in particular to parties, and in that sense, again, if we're going to start thinking about things like alignment theory, it may be very helpful to put that. We also might note, by the way, on Citizens United, that corporations tend to be much more centrist in their giving, at least publicly traded corporations, if we look at their PACs. Of course, when we study PAC giving, to a large extent, we're studying that corporate giving. So again, if you're looking for the more moderate donors, that's actually where you find them. And Citizens United has made it possible for them to get into the game. But I was going to start pointing out that now we have still more ramped up rhetoric, and we've heard it all this week. Comparisons to Dred Scott and so on. Bert Newborn, very prestigious professor at NYU, recently published something on SCOTUS blog yesterday, likening it to slavery and segregation. Really? This is like slavery? McCutcheon versus FEC is like slavery? He says we're under economic serfdom now. Now this kind of rhetoric, and this is not, again, this is not your Ward Churchill nutjob professor, right? Bert Newborn is a very highly respected, very established, credentialed professor, a doyen of the legal establishment, is making this kind of statement. Why? To try to gin up opposition to this. We've also seen a push toward bad government. I'm not going to go into that, but suffice to say that efforts now to regulate campaign finance are to a large extent one of the reasons that we have the IRS scandal over the last couple of years. They've been trying to regulate through the Securities and Exchange Commission, through the Federal Communication Commission, through organizations that have no expertise in the area. This is bad government. This is the kind of thing that leads to gridlock and poor government and makes people unhappy. And finally, what we're doing here is we are threatening long, well-established rights. Again, remember that position of the government in Citizens United. One vote away from winning, that you could censor books and movies, right, if they were about a politician in an election year, okay? And Justice Breyer, in his dissent this week, talks about the collective right of speech, and that should override these petty individual rights. You know, in the Cold War, it was noted that all of the communist countries had wonderful Bill of Rights that definitely protected the right of everybody to speak, so long as their speech was in accordance with the collective will, right? That's the kicker. And one of the things we've realized over the last 20 or last 100 years is that it's not just that this First Amendment is important for democratic debate, it's that we cannot trust the government to regulate in this area. So with that, I will wrap it up by saying we have, to a substantial extent, destroyed the village in order to save it. And the Roberts Court is gradually starting to destroy the village, or to rebuild the village, to recreate a system of freedom in campaign giving and political speech that we operated under for most of our history. And I think the most important line in that opinion is one in which Justice Roberts says, those who govern should be the last people to help decide who should govern. That is the essence of our political choice and our political freedom. And I think we should be glad that there's this new skepticism on the court. Thank you.
I think in light of the hour, we will allow the three speakers to all get their opportunity. The other two speakers will have their opportunity, and we'll save questions for the end. So,
thanks. Why in polarization, why is it always sitting on the sides? So I can talk a little bit about, it feels like yesterday's news, Citizens United, but in some ways it's also going to be tomorrow's news, which is the continuing restrictions on corporate contributions, remembering that Citizens United is a case about corporate independent spending. And in some ways, McCutcheon potentially shed some light on what will undoubtedly be one of the court's next big decisions, which will be to consider and possibly invalidate the federal ban and the bans that many states have on corporate campaign contributions. For more than a century, restricting corporate money has been a special focus of campaign finance law. Much of campaign finance regulation is rooted in popular fears about private wealth corrupting the political process, and there is no greater symbol of private wealth than the business corporation. Concern about corporate power dates back to the early 1800s, and before the end of the 19th century, the states had begun to pass laws limiting corporate campaign activity, and the first federal campaign finance law, which Brad already alluded to, was the Tillman Act of 1907. Again, it's well past the 100th anniversary, which banned corporate contributions to federal candidates. When labor unions became powerful organizations in the 30s and 40s, Congress added them too to the ban, and many states have similar restrictions. These restrictions reflect concern not just about private wealth and power, but also about the nature of these organizations, which are not natural persons capable of voting and running for office, but creatures of the law that enable them to form and wield economic power. It also reflects concerns that, to use Justice Brandeis's phrase about corporations, that they'll be Frankenstein's monsters, taking the power that the law gives them and using that the government has given them and turning it on the government. The adoption of limits on corporations and unions also reflected concerns that as these organizations grew in scale and size, their constituents, corporate shareholders and union members, could no longer control the corporate managers and union bosses actually making political spending decisions, so that those decisions did not actually reflect the views of the constituents. The managers and bosses were, in another phrase of Justice Brandeis's, using other people's money for their own ends which could be at odds with the interests of the very shareholders or workers who were the source of these funds. These long-standing restrictions on corporations and unions, however, are in deep tension with the central themes of modern campaign finance jurisprudence, with its focus on freedom of speech and association, and its hostility to equality as a justification for regulation. For roughly 35 years, the court vacillated with Buckley and Bellotti, well, Bellotti being the first corporations case, through Austin, through National Right to Work Committee, Austin, FEC versus Beaumont, Wisconsin Right to Life, until it seemed to come to rest, certainly in the area of restrictions on corporate and union spending, it did come to rest in Citizens United. But there are still issues that remain, the most important one being, I think, the treatment of the ongoing bans on corporate and union contributions. We'll talk a little bit about the history of this, so just maybe a couple of anecdotes, and then focus on what I think are the three principal arguments for continuing to ban corporate and union contributions. And basically say, I think the first one fails, the second one is iffy, and the third one is strongest for corporations, but maybe been undercut by McCutcheon. The most important traditional argument for the special restrictions, which is the distinctive wealth and power of these organizations, fails to justify them. Neither corporations nor unions considered as a category of campaign actors is distinctively wealthy and powerful. They are legal structures that house entities that vary considerably in size and resources. Many businesses that participate in elections are not even corporations. They are organized in other legal forms. And many of the wealthiest actors who give and spend the most money are not businesses but individuals. So although I think that's what's driving this, it's not very persuasive, at least not on the current model of campaign finance law. Protecting the interests of shareholders and employees provides a better justification for the additional restrictions. Although the Supreme Court summarily dismissed the shareholder protection rationale in Citizens United, the argument is a stronger one than the court found, particularly with respect to corporate activity. It ought to be enough to support the restriction, the ban on corporate contributions, but very well may not be. The strongest argument for regulating corporate campaign activity, and as I'll get to later, it's not an issue for unions, is the ease with which the corporate form can be used to evade currently constitutionally valid restrictions on and requirements concerning individual donations and expenditures. In nearly all states, it's extremely easy to create a new corporation. As a result, a single individual may quickly generate multiple corporations and use these new entities to circumvent the legal rules governing the individual's campaign finance activities. Without law specifically addressing and restricting corporations, individuals could easily evade campaign finance laws. Indeed, in the emerging post-Citizens United era, corporate entities have become an important tool for evading reporting and disclosure rules. Ironically, the key corporate actors in recent elections have not been the big business firms that originally inspired the corporate restrictions and still dominate public hearings about the corporate role, but not-for-profit corporations, called into existence as a vehicle for hiding very large contributions, including some from businesses, but mostly from wealthy individuals, from public disclosure. If the ban on corporate contributions is struck down, we're likely to see a growing role for sole shareholder or small closed corporations or LLCs, for-profit organizations, which would function largely as conduits for individual donations. On that basis, there's a continuing role for special rules for corporations based on the circumvention possibilities of the corporate form and other legal forms for creating and organizing artificial legal entities, recognizing that we still have to digest the meaning of McCutcheon for the anti-circumvention argument, to which the court was quite hostile. A couple of thoughts about history. One, just a couple of quotes, really, showing how corporate campaign spending has been a perennial concern in American politics. In his fifth annual message to Congress in 1833, President Andrew Jackson hotly denounced the campaign spending of the Second Bank of the United States. This great and powerful institution, which he asserted, had been actively engaged in attempting to influence the elections of the public officers by raising its money. In the 1832 election, Jackson declared, "The question is distinctly presented, whether the people of the United States are governed through representatives chosen by their unbiased suffrages, or whether the money and power of a great corporation are to be secretly exerted to influence their judgment and control their decisions." And 3 decades later, Abraham Lincoln wrote in a letter about his anxiety about corporate corruption of the political process. Due to the Civil War's generation of enormous profits for government contractors, Lincoln wrote, "I see in the near future a crisis approaching that unnerves me and causes me to tremble for the safety of my country. Corporations have been enthroned, and an era of corruption in high places will follow, and the money power of the country will endeavor to prolong its reign by working upon the prejudices of the people until all wealth is aggregated in a few hands and the republic is destroyed." Talk about ramping up the rhetoric. For that we had Abraham Lincoln to thank. The real concern about corporations didn't really emerge until the late 19th century, and in fact due to civil service reform, political parties could no longer rely on assessments on elected officials and their partisans and how to find other sources of money, and corporations became a major source of that. They became controversial. In 1891, Kentucky became the first state to ban corporate contributions when it amended its constitution. To do that, that provision is still in the Kentucky Constitution. By 1897, following William Jennings Bryan's unsuccessful presidential campaign, Tennessee, Florida, and Nebraska followed suit. Soon more states did. Congress followed suit with the Tillman Act, which itself had been endorsed by Theodore Roosevelt in his 1905 annual message. And the law continues to unfold in this area. I'm going to skip over the history in the interest of time and turn back to the question that I opened up with, which is now that we have Citizens United having struck down the corporate spending ban, what's the status of, what is likely to be the status, or what could be the status of the corporate contribution and union contribution bans? And again, I return to the three arguments likely to be raised: that these entities are distinctively wealthy and powerful with unusual capacity to dominate politics unless their spending or contributions are prohibited, that they are controlled by managers or officers whose spending decisions may not reflect the views or be in the interests of the shareholders or employees who are the source of their funds, and that they are artificial entities. The original concern about their artificiality is that their participation in campaigns is inconsistent with the norms of democratic self-governance, but I think the real concern that artificiality gets at is their infinite creatability and proliferability. Those are not words. Although much of the concern about Citizens United is driven by the first argument, the fear, as President Obama, another rhetoric ramper-upper, put it, of a corporate takeover of our democracy. That is the weakest argument, for reasons that I'm going to get to in a second. I think that the real concern, is with the second and especially the third. On the question of organizational wealth and power, that argument confuses wealth with the corporate form of organization. Not all organizations that take the corporate form are wealthy. Most are quite small and have rather limited resources. Moreover, many entities that take the corporate form are not business corporations at all, but not-for-profit organizations. Indeed, it's striking that the business corporations themselves have played a very small role in campaign finance litigation. The corporations that have brought the most significant challenges, the restrictions on corporations, are entities like the National Right to Work Committee, Massachusetts Citizens for Life, North Carolina Right to Life, SpeechNow.org, and Citizens United itself, nonprofits in the corporate form. These are not wealthy organizations, and to the extent that they do have money for politics, it's not because they are able to convert success in the economic marketplace into political influence, but because donors support their political views. The corporation is a legal form useful to its organizers. It's potentially a means of creating wealth, but it's not wealth itself. Conversely, not all wealth is corporate. If we're worried about Microsoft, we should worry about Bill Gates too. And certainly the most dramatic campaign finance figure in the 2011 election was Sheldon Adelson, who spent $91 million of his personal or family money on resources. And the wealth and power argument is particularly weak for restricting unions. At one time, unions were a powerful force in American society. At one time, something on the order of 35% of employees were in unions. The actual number now is well under 10%. Indeed, today, labor unions account for a smaller percentage of the workforce than at any time since the beginning of the 20th century. To be sure, they're far from powerless politically and often play an important electoral role, particularly at the state and local level, but I don't think they're distinctively more powerful than any other organizations. So I think the wealth and power argument really is a red herring, although it is the one that draws the most public attention. The second major argument is the other people's money concern, which is the concern about protecting shareholders and employees. This argument itself reflects a number of underlying concerns. First, corporate executives and union bosses may use treasury funds to advance their own interests, which may be adverse to the interests of shareholders or employees. The concerns about this date back to 1905. The New York State's Armstrong Commission, which found that New York's life insurance companies were using policyholder funds to win legislative support for measures that limited the ability of policyholders to sue managers for breach of trust. Second, even when corporate spending is not actually opposed to the interests of shareholders, their corporate spending does not necessarily advance their interests. There's a growing academic literature which has found that with the exception of firms dependent on government contracts or operating in heavily regulated industries, corporate political spending does not result in economic returns for the firm, such as improved stock price. Indeed, there's considerable evidence that firms that invest heavily in political activity, other than contractors or those in regulated fields, actually do worse than other firms, and that in some respects, corporate political spending is a marker of a poorly run corporation. Third, even when a corporation's or union's election spending may be in the interest of the organization as a whole, it may not be in the interest of all the shareholders. For members as individuals, shareholders may be interested in using the corporation to advance their wealth, but they have other interests as parents or consumers or citizens, which may be at odds with their interests as investors. Even if the corporate contribution is good for them as investors, it may be adverse to their other values, and in fact overrepresent them as business people, or as investors relative to their other concerns. So there is an arguable underlying problem here. In Citizens United, Chief Justice Roberts condemned the shareholder protection argument, arguing that it's extraordinarily paternalistic for the government to take the position that shareholders are too stupid to keep track of what their corporations are doing and can sell their shares if they object in the corporate context. Well, that kind of misses a lot of the basic facts about how corporations are run. First, it's not easy for shareholders who disagree with their first political actions to voice their concerns or attempt to change the corporation's policies. It's extremely difficult for shareholders to keep track of what their corporations are doing. Corporations are under no legal obligation to report their election spending to shareholders. Second, even when a shareholder knows about a particular corporation's spending, there's not much you can do about it. Traditional responses to something you don't like are under the rubrics of exit and voice. Exit means sell your shares, but any sale of shares will come, A, after the disliked spending has occurred, and will require either the shareholder to take a loss or to trigger the application of the capital gains tax. Either consequence would operate as a monetary penalty, discouraging sale. The other alternative is voice, but in fact, under corporate law, shareholders have no voice on a corporate spending decision, consistent with general corporate law principles. General corporate law principles vest the vast majority of corporate policy-making decisions in management. The decisions whether to engage in election spending, how much to spend, and which candidates or ballot measures to support or oppose are for management. Shareholders have no legal say on these questions, so it's not clear that if we think there's a problem here, that the shareholders can actually take care of themselves. Is that enough? Is shareholder protection a constitutionally strong enough justification for limiting corporate contributions? Well, that depends on three different things. What's the standard of review? How important is preventing the use of funds for a goal you don't like as a justification? And are there less restrictive alternatives? On the importance of the justification, we have a lot of case laws finding a strong First Amendment interest in protecting people from being compelled by government to express or subsidize beliefs they don't share. But in this context, it's not the government doing the compelling. Some people have argued that it's public law that permits corporations to organize. That strikes me as a bit of a stretch. It's not clear that there's a government compulsion on people, shareholders having their money used by corporations in the absence of their support. But we're in a funny situation. Given the absence of state compulsion, there's no First Amendment right to limit corporate spending, but is there an interest sounding in First Amendment values that supports government efforts to protect shareholders from the unwanted use of their investments for political activity? It's arguable but uncertain. I think you could argue for it, but I'm not certain it would win. Second question turns on, are there less restrictive alternatives for protecting objecting shareholders? People have presented ideas such as an opt-out right, that shareholders could somehow opt out of corporate spending, which would be modeled on the opt-out right that employees have with respect to labor union spending, or the requirement of voting, that the decision of a corporation to contribute money to a campaign be subject to shareholder voting, as it is in England. These strike me as either incredibly cumbersome and likely unworkable for the opt-out right, or inadequate, because even unless you had a really unanimous consent, there'll be some shareholders who will be unhappy with their corporation's spending or contributions. Final question is the standard of review. Until earlier this week, it was clear that contributions were viewed as less of a burden on First Amendment interests, and so were subject to a less rigorous degree of scrutiny, merely that they be closely drawn to match a sufficiently important interest. The shareholder protection interest might be considered sufficiently important to support a ban on the contribution of corporate treasury funds, even if it isn't constitutionally compelling, but it's not 100% clear. Certainly, the case would be strong if there was an exemption for corporations without shareholders, and for corporations in which there is unanimous shareholder approval of the contribution. It is worth pointing out that dissent or objective protection provides no justification for limits on union contributions, As a result of a long string of Supreme Court decisions, employees required to pay union agency fees have a right not to have those fees used for political purposes and to have their required fee payments actually reduced. By enabling them to opt out of compelled support for political activity, the court has already provided objecting employees protection from compelled support for political activity. That is a less restrictive means of protecting employee interests than barring union treasury fund expenditures. As a result, objective protection, even if it's a compelling government interest, could not be a constitutionally sound basis for limiting union campaign contributions. Final concern here, and the one I think, as we're running out of time, I'll zip along, although I think I've been pretty zippy until now. The clearest argument for restricting corporate contributions is I call it the artificial entity argument, though again, it's less the artificiality, which isn't the problem, but the ability to generate new corporations with great ease. It is extremely easy to create a corporation. In most states, a new corporation can be formed simply by filing a few papers and paying a nominal fee. A single individual can generate multiple corporations that he or she controls and can use to circumvent the legal rules governing campaign participation. The adoption of a dollar limit on the size of an individual's donations to a candidate would be meaningless if the individual could proliferate a dozen new corporations, each of which could separately donate up to the legal maximum. Similarly, enabling corporations to participate in election campaigns can lead to the frustration of disclosure requirements, as a donor can easily disguise his role in a campaign by creating and putting money in a corporation which contributes to a candidate or to an independent expenditure committee that spends in support of a candidate. Individuals may be able to use their minor children to evade contribution limits, but it is far easier and quicker to generate multiple corporations, not to mention not having to pay for their college educations. The use of corporations chartered just for electoral purposes to evade disclosure requirements has become a regular occurrence since Citizens United. In one well-documented incident, an entity known as Specialty Group, Inc., which was incorporated on September 26, 2012, contributed $10,575,000 to Freedom Works for America, an independent expenditure political committee, in the month of October 2012. That made Specialty Group Inc. the fourth largest donor to independent spending groups in the 2012 election. Freedom Works itself was the sixth largest outside spender in 2012, and Specialty Group accounted for more than half of its funds. However, according to news accounts, Specialty Group appeared to have no website describing its products or services, gave its address as a residence, and was not required to make any disclosure concerning the source of its funds. Similarly, corporations and other entities like limited liability corporations, which are a big deal in my home state, New York, LLCs, can go out of existence, change names, reform, or work through subsidiaries or affiliates in ways that at the very least hinder the ability of the media and voters to track the flow of funds from original donor to ultimate campaign recipients. Often little more than shadow mailboxes, these legal persons have become a key mechanism for evading disclosure laws. The ease with which politically active artificial entities can be proliferated, reorganized, and dissolved makes enforcement of, until now, constitutionally sound campaign finance laws far more difficult. At the federal, as Ann Revelle, then chair of the California Fair Political Practices Commission and now a member of the Federal Election Commission, has observed, people are willing to use circuitous routes to avoid telling the voters who is behind campaigns. She made her statement while announcing the imposition of a $1 million civil fine as part of the settlement of a case brought by the FPPC, the California Fair Political Practice Commission, and the California Attorney General against two nonprofit corporations that together funneled more than $15 million into a campaign against two ballot propositions on the 2012 California ballot. The money, which originally derived from a handful of super wealthy individuals, was channeled from the originating donors to a group called For Americans for Job Security, which then transferred the money to the Center to Protect Patients' Rights. The ballot propositions in questions had nothing to do with patients' rights. And then on to the Arizona-based Americans for Responsible Leadership and the Iowa-based American Future Fund, before the funds were finally sent on to the Small Business Action Committee and the California Future Fund for Free Markets for spending to oppose the ballot measures. It was, as one news account put it, a daisy chain of organizations that operatives took to skirt disclosure obligations. Similarly, the Western Tradition Partnership, it's also in a recent Supreme Court case, touted to prospective donors in its literature, we're not required to report the name or the amount of any contribution that we receive. So if you decide to support this program, no politician, no bureaucrat, and no radical environmentalist will ever know you helped make this program possible. You can just sit back on election night and see what a difference you have made. This recent practice involved using corporations to evade disclosure, but corporations, if allowed to make campaign contributions, could easily be used to evade those limits. A recent investigation of campaign practices in New York, which permits contributions by both corporations and LLCs, that is limited liability companies, found that it is standard practice for organizations to generate LLCs and subsidiaries to make campaign contributions. The New York study found that one entity had utilized 25 separate LLCs and subsidiary entities to make 147 separate political contributions, totaling more than $3.1 million over a 4-year period. Although rules can certainly require that all related entities be subject to a single contribution ceiling, such rules can be difficult to write and even more difficult to enforce. Corporations can be structured to avoid formal affiliations, and determining whether two firms are in fact connected will often be a difficult task for enforcement agencies. Of course, as the New York example indicates, corporations are not the only entities that can be used to evade contribution limits on individuals, and the anti-evasion concern would justify similar restrictions on LLCs and coupled business entities. As with the shareholder protection argument, anti-evasion does not justify the prohibition of labor union donations. Individual union dues and agency fee payments are well below the dollar cap on individual donations, and there seems to be a little likelihood or evidence that a union could be created by a wealthy donor solely to end run the cap on individual donations. To be sure, if unions are allowed to make contributions, then enterprising donors and the politicians seeking their funds might very well try to label any new organizational form a union. The real issue is that posed by donations by any paper entity that purports to be a membership organization. Any campaign finance regime that limits individual contributions but permits contributions by membership organizations needs rules to prevent the use of such organizations to evade the restrictions on individuals. Unions are no different from other organizations that receive relatively modest dues from their members or affiliates. Unions are not a special case for the anti-evasion interest. Corporations, because of the ease of their creation, the ready possibility of multiple single shareholder corporations controlled by a single individual, and the fact that they are in fact used to evade campaign restrictions, do seem to be a special case. The footnote, and I am just about done, this is on the impact of McCutcheon, which is the court does take it continues the dark view it's taken of the anti-evasion justification, the famous phrase prophylaxis piled upon prophylaxis. One strand of McCutcheon was rejection of the argument that you needed the aggregate cap limit as a backup for the individual limits, and so I think this anti-evasion argument, while important, will need to be toughened up. The other is the focus on less restrictive alternatives. Again, much of the majority's, the opinion from the court in McCutcheon's discussion was exploring other alternatives, including the existence of current restrictions on the ability of donors to earmark their funds through other committees, and the reliance on the existence of such rules. The court did not take seriously the argument that these rules are actually very hard to enforce, and to the extent that my argument relies on the difficulty of enforcing restrictions, it may not get much weight in a future court. But that, I think, just to sum up, as we look forward, as surely if not the next case before the court, one of the next cases will be the ban on corporate contributions. I think they're the main argument is going to have to be the anti-evasion.
Going to enlist your cooperation in helping to understand something that is simultaneously old and new. And to say, like so many other things about campaign finance, it's not understood very well at all. And this is the idea that money moves. Of course money moves. It's not just sitting around, it moves. Political money is no exception. The 1996 campaign was famous or infamous for the movement of money globally, where operatives of both parties were in yachts offshore in Singapore and Shanghai collecting money from God knows whom, but we did know for what. And the Senate then held a series of sanctimonious hearings that were cut short just as they were getting to the nonprofit entities, which I know about because I was getting calls from staffers on the Hill saying, will you come and testify, will you come and testify? And of course I didn't, because they just stopped holding the hearings. Money moving is obviously pretty controversial, and has been for a long time. There's been a new flurry of interest now about money moving when the Center for Responsive Politics and their website, opensecrets.org, created a fascinating chart of money in motion in Koch world. Now, I'm not interested so much in talking about the Koch brothers. I am interested in why we can learn something possibly from the database that was built to generate this chart, why the chart is interesting, and what it is that we might want to ask about it. The first response to this research is that everybody who said disclosure will solve everything have stood up again and said, see, we told you disclosure would solve everything. But I think the first takeaway from this fascinating chart, and you must have seen it, it's ubiquitous. I expect to see it on milk cartons anytime soon. My first takeaway is that disclosure isn't going to solve much here. There's a lot more to this than disclosure. After all, the Koch brothers are not hiding. The other celebrity billionaire donors just really won't get off the stage and off our television sets, even in a period of time which I used to think archaically apparently could be called between elections, a concept which now doesn't seem to have an empirical referent at all. So assuming that there's more to these, whatever they are, aggregates of entities, the money trails are something. They're actors. They're separate from their components, and yet integrating components in new ways. So what is it? It's not a conspiracy. It may not even be something we disapprove of. But what is it? How do they work? And how does it fit into campaign finance jurisprudence? I was interested in McCutcheon because there's a lot of talk in McCutcheon about money conduits. And that's part of what we see here. What I can say that we know now, and I can say this with some confidence, money trails don't just happen. They're constructed thoughtfully for specific purposes and at considerable cost, because I am pleased to say, especially to the students in the room, lawyers don't work cheap, and neither should you. Number two, I think that the existence of the money trails refutes the hydraulic theory, which is an overblown word for the hydraulic metaphor that has so permeated and led to confusion in campaign finance analysis. Money doesn't just slosh around, money is pumped. And the real way to understand it is to read Joan Didion's essay on her visit to the Hoover Dam called Moving the Money in California, of vast machines with few people. And I commend a little Joan Didion to you to get you in a mindset for understanding this topic. So how would we describe a money trail if we're going to find some word that seems somehow more grown up and analytically powerful than money trail? And how are we going to capture its reality as something that's both constructed, which is to say intentionally structured in a particular way, and managed? Well, maybe it's a coalition. That's a nice word. Your mother would approve of that word. There's no conventional indicia of control in a coalition and in the money trails, I think. There's no stock ownership. There's no one with the right to appoint the directors of a nonprofit. There's collaboration through a series of agreements, mostly unwritten, for limited action for defined purposes, like, say, winning an election. The liberals have been trying to put together coalitions for years, and of course, being liberals, with almost no success whatsoever. The latest example for this is what I like to think of as the smackdown of 2012 in Washington, D.C., when independent sector, that self-styles itself as the capstone of the 501c3 world, modestly appointed itself as the leader of a new coalition and invited other nonprofits to join it, which caused the redoubtable Alliance for Justice in Washington, D.C. to put out a press release which can be summed up in the question, you and what army? Suggesting that they would not be aggregated and they would, continue to speak for the people in their own voice. I love this stuff. The liberals, of course, have some version of their own money trails, and they've had them for a long time. They're probably just not as good as getting them organized. and have had either billionaires who've given them less money or billionaires who've insisted from the beginning on perhaps a little less control. So one possibility is a money trail is a coalition. Number two, a money trail is simply an aggregate of special purpose entities, not controlled in any way, but coordinated by a group of managers. And this, the mother of all special purpose entity operations, was the Enron Corporation, which collapsed dramatically, taking a major accounting firm with it and nearly doing in a major white shoe law firm, but they skated. Enron was on the cover of Business Week as the modern corporation of the future the week before it collapsed. Now, what we found there is that you can do a lot with special purpose entities if you don't put them all together through any formal control mechanism. I will remark that a group of IRS auditors in Houston figured it all out very quickly. When their analysis reached the sophisticated folks in Washington, D.C., those folks were unable to believe what they were seeing, although they never refuted what the auditors were doing. So the guys with the pen protectors and the shirts from Sears were right very early, and the sophisticated tax IRS people and lawyers, we took a long time. The lesson here is that data matters, and being open to alternative explanations and the important frameworks also matter when we launch something like this. Number three, maybe they're a political version of tax shelters. A series of transactions, all of which seem incredibly stupid and inexplicable, until you actually figure out what they're doing and why, and then you can see the steps along the trail and why they matter and why this was incredibly clever. And every step along the way seems very stupid until you get to the final end result. That's possible. Or maybe it's a network. The economist Richard Coase said that entities can be defined by control or by contracts. Contracts are understandings, and entities can engage through this kind of a mechanism in a network format without an existential threat to the existence of the components. Here, once we admit that all will not be revealed by disclosure, we can begin to say, let's ask the big question. What is the transaction? Buried in there somewhere, there is probably a transaction. And that requires us to begin to say, why are these particular types of entities in this money trail? Number two, why is the money moving in particular sequences of dyads? The source to the recipient. The recipient, it becomes the source off to another recipient. Over and over again. And why are some entities getting their own money back in a kind of circular flow of cash? And then three, which of these sub-transactions matters in different ways? I will say that tax law and federal election law both have elaborate theories of conduits and money movement, but they are unlikely to be sophisticated enough to explore this. So the questions then are, why are people doing this operationally? And one is, of course, there is a desire to prevent disclosure. These celebrity billionaires don't care at all. In fact, they're kind of enjoying being famous and saying things to Andrea Mitchell on TV about innovative uses for aspirin, which has to rank as some of the grandest TV I've ever seen. This was Foster Freeze, the mutual fund magnate who was having a fine time. It's more for entities like Target, for entities that sell to the general public, but because of a position they took on a referendum in the Twin Cities, they risked a lot of backlash from many of their consumers. There are businesses who don't want it known that they are producing or sending money to particular candidates or particular issues. Number two, which I think is extremely important to the money trails and to understanding them, is to create a command and control structure of central management to do things like stage money for rapid responses during the heat of the campaign, and also never ever again to let political operatives waste as much money as they did in the 2012 election. The people who are funding these money trails are not people who misunderstand money. These are people who make money, and if they are making money, they understand the value of it and the difficulty of making it, and really, why should they just throw it away on a bunch of self-appointed, self-described expert operatives who didn't elect a president and didn't elect a U.S. senator? I think they're learning that they can do this themselves. Now, McCutcheon noted chains of attribution in political money and suggests this dilutes gratitude, and therefore any worry about corruption or improper influence would go away as money moves through multiple chains. Well, that's a fascinating perspective. I just think there are more people lining up to be thanked. But we shall see. We shall see. I also think there's some desire to mask the users of the money. And I think this may be particularly true with liberal groups who, it would appear, are collecting money from sources they would find embarrassing if the rest of us knew. The users of money may have as much on the table and as at stake in this disclosure business as the sources, and maybe more. And then I think there is a nice, lovely technical issue about how do we determine the size of a general treasury to a nonprofit conduit. Nonprofits, after all, get contributions. If the money chain is working, they're getting a recontribution of their own money, sometimes 3 and 4 times. By my reckoning, that's going to increase the size of the general treasury, which allows them to effectively argue that, in fact, they can spend a boatload of cash on politics without having the majority, their primary expenditure, be for politics. And so some of it may just be to amp up the general treasury size of some of these nonprofit entities. Now, if any of this is true, so what? So they want to win an election. Doesn't everybody? My husband ran for Congress. I didn't much think of myself as a recruit for a congressional life. In fact, I didn't think that was palatable at all. But he would have made a wonderful member of Congress, except, of course, blissfully, he lost. And we have lived happily ever after for decades and will continue to do so. But of course, I wanted him to win for his own sake, and of course for that of the Republic, as everybody says when running for office. Everybody wants to win an election. There's nothing wrong with that. There's something pretty healthy about it. But I don't think one builds a money trail of this complexity, of this sophistication, and I don't think the Kochs are the only ones doing it. And so I think we need to get this kind of ideas, one party or one group, off the table, really. I think it's about a profound level of agenda setting. I don't think it's small issues about environmental regulation, although that's some of it. We can trace support for candidates who have particular views on particular issues, but I don't think it's that. I think what we're in now is an utterly fascinating time in American history in which we're having a debate about the meaning of liberty. Now, maybe I've been in academia too long. That can rot your brain if you don't get out and see people and get your hands dirty and interact with the rough and tumble of American life. But I find ways to do that. So I'm thinking maybe my brain hasn't rotted totally yet. I think we are having a contest over liberty in the following dimensions. Justice Souter, at his address at the Harvard commencement of 2010, gave a wonderful address that is found online in the 2010 Harvard Law Review on the process of judging, in which he referred to the preamble of the Constitution, where are stated the great principles on which the Constitution rests and the great purposes of our Constitution. And he pointed out that we really can't have all of them simultaneously all of the time. And judging is about walking the lines in how you preserve all of them while simultaneously knowing you can't have all of them simultaneously all of the time. I think we now have a fight where people are trying to organize for a broad existential victory that says we can have the ones we like all the time. And that liberty is the greatest of these, and we mean to have it. And liberty defined as we mean it to be defined. It is an era, I think, when liberty is again defined as consistent with the interest of those who have proven themselves capable of being successful, much as an earlier era in our history. And where inequality is a natural sorting device indicating who is deserving and who is not. Our jurisprudence rests on this. We celebrate in our Supreme Court more speech while declaring that the fact that we have fewer speakers capable of being heard, those speakers are taken out of the agenda of public discourse. It does not matter to me at all, as it does to some, that McCutcheon might give more money to political parties. Remember, I was a political wife. I could care less, and my husband was a Democrat. I come from a Republican family in Wisconsin. Ain't love grand? But I've long given up my ancestors' enthusiasms. So my husband was running, and I don't think the Democratic Party did anything for him at all. And they should have, for the sake of the Republic. What matters to me is the substance of the public debate and the range of voices who can be effectively heard in that public debate. That's mattered to me really forever. And by that I mean from the time I was a child, and my grandfather was a county chair for 40 years in the state of Wisconsin, where he was a civic activist and good government person who never took a dime of public money. And I'm proud of him, beyond words that I could say for that kind of governance. What matters is the substance of the public debate and a culture that allows us to listen to each other. I think what we have now is a culture where we have divided ourselves not only into those who have proved that they qualify for success by being successful in terms of money and prestige and the kind of jobs that we have, but also to those who in a campaign may speak loudly and effectively, and those of us who should listen. We all should listen to each other. But now we have a system where we have a nation of speakers and listeners, and that is where the destruction of our system becomes risky. Chief Justice Roberts, at the beginning of McCutcheon, mused on participation and all the ways we could participate. But given the inequality in the country now, none of those are open to ordinary Americans who are under the 1%, because the 1% doesn't matter either. You gotta be much higher than that. I once had a little guy who objected to something I'd said. It's hard to imagine anyone would, but he had emailed me from some place. And he said how disappointed he was in me to hear a tax lawyer saying these things about progressive taxation. And he said, and I want you to know I'm almost in the 1%. I thought, how pathetic, how pitiful. Is that what we are? Almost in the 1%? Oh, Bubba, I get paid well. And I have a husband with a day job, but I didn't respond. That is not the answer to it at all. The answer is this. The Supreme Court is not the only player in shaping the public narrative of our democracy. And so this summer, I plan to spend a fair amount of time reading a book called Capital in the 21st Century by a Frenchman, Thomas Piketty, who I think should well replace Tocqueville as our touchstone just at the moment, and certainly in the nonprofit world. Piketty, P-I-K-E-T-T-Y. which considers the implications of inequality and structural inequality and the damping down of mobility for our democracy and everyone else's. So if the money trails are going to consolidate our oligarchy, then I don't care if they're a coalition or they're Enron. It is just one more bit of negativity. If the money trails are coalitional, and if everybody figures out how to run them, then I still stand for disclosure, but I take it as given that money is going to move, and it moves through several hands. Fine, I'm a tax lawyer. I love to trace money trails. I'm going to enjoy this immensely. What I am not enjoying is seeing America divided between the rich and the poor, and the speakers and the listeners, and that we have to fight.